I was in Brussels last week at a conference, and one of the topics covered by the panel I was on was concentration and what's been said recently about concentration and the debate that's going on. So I thought I would talk about that a bit because it's been on my mind. It would be an understatement to say that antitrust is a hot topic these days, and much of the attention has been focused on prominent tech, media, and telecom companies. Tech companies in particular have taken a central role in the current debate over industry concentration as well as the implications of so-called big data. Of course, the concept of a platform isn't new, and it's really the birth of the internet and mobile devices that have fueled an expansion in platforms in today's digital economy. But newspapers, shopping malls, credit cards, we've been talking in many ways about platforms for a long time. Platforms, of course, bring tremendous innovations to the marketplace, lowering transaction costs and enabling sellers and customers to find each other more easily. Mobile platforms like iOS and Android enable app developers to launch new products and services and reach thousands of customers instantly. Expedia and eBay help consumers compare prices and products more easily across different sellers. Platforms really do bring vibrant new competition to traditional industries. Uber and Lyft, of course, disrupted the taxi business and provided new opportunities for people on both sides of that platform. And Airbnb disrupted the hotel industry, giving consumers more options and giving homeowners additional revenue opportunities. So nobody can really deny the benefits that digital platforms provide. But some people are concerned that a few of today's leading platforms have become too big, that markets are becoming increasingly concentrated, and they're looking to the antitrust laws to help. I just, this week, I think on Wednesday, turned on one of the morning financial talk shows, and there was a congressman talking about breaking up some of the big tech platforms. But what's the evidence? We should focus on the evidence because over the past few years, a number of articles have suggested that industries are becoming more concentrated, and some of them certainly are. In fact, there are a number where a handful of firms account for an increasing share of the marketplace. And some people do blame lax antitrust enforcement for this occurrence. But before we rush to judgment, we need a better understanding of why there's increased concentration. Is it due to anti-competitive behavior? Are there regulatory barriers to entry that are causing this? Are firms big because they're better at what they do? The answer isn't really that simple, and it does and differ across markets. But I'll start with the evidence on concentration itself briefly. In 2015, the Council of Economic Advisors issued a study on competition and market power, and it found that concentration in the United States has increased in recent years. Another study relied on census data to conclude that more than 75% of U.S. industries have experienced an increase in concentration levels over the last 2 decades. A number of these studies claim that this increased industry-level concentration is causally related to levels of antitrust enforcement. But some criticisms have emerged, including several that were published last month, one by Carl Shapiro and one by Greg Worden and Luke Frobe. And they challenge these studies because they rely on industry-level census data rather than measuring concentration in relevant antitrust markets. They're informative articles, and I recommend them to everyone. The studies that rely on the U.S. Census data look at broad categories like retail trade or utilities or finance and insurance, that's one category, and healthcare. But as most, if not all of you know, a relevant antitrust market is invariably much narrower because it includes only products that are close substitutes from the consumer perspective. If the studies don't capture concentration in a relevant antitrust market, they really don't meaningfully tell us anything about changes in competition or the kind of competition that we're interested in. But even if one assumes for the sake of argument that there is an increased concentration even in relevant antitrust markets, we should consider the possible reasons for that trend. One possible reason is dynamic competition based on efficiency. If one firm is much more efficient than its rivals, it can displace inefficient competitors and leave fewer firms in the market. Some have called these exceptionally efficient firms superstars, although I confess when I was in Brussels, I was concerned that that's becoming somewhat of a pejorative label. In fact, economists have observed that increased variation in productivity levels across firms, and that there are industries that have the industries that have highest concentration levels are also those with the greatest productivity and innovation growth. And that really shouldn't be surprising. When firms are able to operate at lower costs or produce better products than rivals, they can increase their market share and drive out less efficient competitors. And that's a process that may result in higher concentration, and that's a result of the competitive process at work. As Makan Rahim has said, rather than a failure of antitrust, concentration may be the byproduct of healthy competition as the most innovative and efficient firms grow and attract customers. Indeed, if firms are gaining market share because they're winning consumers through competition on the merits, that, of course, should be applauded and not condemned. A second closely related explanation for increased concentration is the growth of platforms and the rise in particular of winner-take-all or winner-take-most markets. Economists have long recognized that economies of scale, including demand-side network effects, can result in concentration, and consumers often benefit from concentration in such markets. Waze is a good example. The more people on the road that use Waze, as I understand it, the more accurate its traffic and navigation services become for other consumers. So drivers may benefit from having all drivers on a single platform rather than having them fragmented across multiple different navigation services. This doesn't mean that winner-take-most markets are without competition. Rather, it reflects the idea of competition for the market being stronger even if there's less competition in the market. Another example that some of you may remember is the battle between Blu-ray and HD DVD that occurred between 2006 and 2008. Blu-ray ultimately prevailed in the competitive battle, but its victory was fleeting. Consumer preferences and technology shifted again, and obviously streaming videos are rapidly replacing Blu-ray discs and HD DVD. I won't have people raise their hands to tell me last time they watched something on Blu-ray or HD DVD. A third explanation that's offered for increased concentration is increased regulatory barriers to entry. Regulation can obviously entrench incumbent firms and keep out entrants. When regulation does create a barrier to entry, it can limit competition, raise the costs of goods and services, and stifle innovation. And of course, incumbents naturally prefer regulation because it preserves the status quo. Occupational licensing is an example. A 2015 White House report observed that the share of U.S. workers holding occupational licenses has increased fivefold since the 1950s, and that licensing requirements have raised the price of goods and services. Another example is the certificate of need requirements that hamper competition in healthcare markets. So, in light of these possible explanations, it's not clear that alleged market concentration is a competition law problem. Indeed, economists have found little correlation between increased prices and changes in concentration, as would be expected if concentration were being driven by weakened competition. For these reasons, I'm skeptical of drastic calls for breaking up firms or turning tech platforms into regulated utilities. Those kinds of blunt approaches may ultimately harm consumers and sellers, the very people that we seek to protect. As we at the Antitrust Division think about our responses to this debate about concentration, we keep four basic principles in mind. First, we have to remember that antitrust laws are concerned with competition, not concentration. Concentration may indeed be scary, but the relevant question is whether competition is still working to protect consumers. Our focus is on the competitive process and applying the consumer welfare standard to protect the consumer's interests in low prices, quality, choice, and innovation. If concentration is a result of more efficient and better firms attracting customers through competition on the merits, we should conclude that antitrust is working as it should. The whole point of competition is that the market, rather than regulators, pick the winners and losers. Indeed, much of the debate over concentration seems to overlook that many large tech companies attract consumers with lower prices and more innovative products and services. A second core principle is that our job at the Antitrust Division is law enforcement, not regulation. We don't have freewheeling authority to regulate or break up an industry. We bring enforcement actions, as many of you know, only when they are supported by the facts and the economics. We also recognize that we at the Antitrust Division aren't business people. We're not experts at determining how businesses should be run in the future or what prices to charge. And even if we had the ability to break up firms because they're too big, it's not clear we know how to do that without harming consumers or the economy. Nor that it's clear that breaking up big platforms would necessarily resolve the concerns that people are voicing, which actually often tend not to be related to competition itself. Third, we need to remember that when we're looking for antitrust violations, as Macon Delrahim likes to say, big is not bad. Big behaving badly is bad. So as antitrust enforcers, we don't object when firms gain market share by competing on the merits, including through superior quality or lower prices. But what we do look for is firms behaving badly by engaging in anti-competitive conduct, such as collusion or exclusionary conduct or predatory conduct. Fourth, we need to keep in mind the need to preserve incentives to innovate. Breaking up or regulating successful firms as if they were public utilities threatens to reduce the incentives to innovate. The prospect of making it big motivates innovators and entrepreneurs to invest in new technologies and products. It's kind of like the lottery. When the jackpot is big, more people buy lottery tickets. Even people who hardly ever play buy lottery tickets when there's an opportunity for an enormous payoff. You may remember the Mega Millions jackpot in October that was $1.6 billion. I confess that I couldn't resist buying a number of tickets, and I know I'm not alone. Something similar happens in the business world. The prospect of a big payout will, as Schumpeter wrote, lure capital into new markets and may thereby produce a perennial gale of creative destruction, resulting in innovative products and services that benefit consumers. So keeping those four principles in mind, we at the Antitrust Division are doing a number of things that may help alleviate concerns about increasing concentration and market power. First, vigilant merger review is a key tool to prevent anti-competitive concentration in markets. Under Section 7 of the Clayton Act, we can seek to block mergers if the effect may be substantially to lessen competition or to create a monopoly. But preventing an anti-competitive merger is far easier than breaking up a monopoly after the fact. Even after the fact, however, we can take steps to protect competition. As our case against Parker Hannifin last year demonstrated, that was where we filed a civil antitrust lawsuit after the consummated merger on the grounds that the merger eliminated competition in aviation fuel filtration products. Shortly after we filed the complaint, we reached a settlement that required Parker Hannifin to divest its aviation fuel filtration assets. The acquisition of startups presents a particular challenge for antitrust enforcers, but it's important to distinguish between two things. On the one hand, acquisitions in which an incumbent firm recognizes a competitive threat from a startup and seeks to eliminate it, that's on the one hand. And on the other hand, acquisitions in which an incumbent firm helps to fund and greatly expand the range of a target's products to the benefit of consumers. The really hard cases are those where both of those incentives appear to be at play. But we do need to be careful about making it too difficult for startups to be acquired. If we remove one of the important exit strategies for entrepreneurs, we may unintentionally reduce the incentives to invest in the first place. And it's important to remember in this regard that a startup's success as an independent firm may not be inevitable. Entrepreneurs often can't take their creations to market successfully on their own, and they may not even be interested in running a company long term. Acquisitions can enable firms with the necessary capital and skill to bring an innovative product or service to consumers that might not have reached them otherwise. A second important development of the Antitrust Division is our emphasis on structural remedies. This has been discussed at some length by AAG Delrahim and myself in other speeches. Our evolution in thinking on remedies is informed by shortcomings that were observed in prior behavioral merger remedies. Back in 1961, the Supreme Court itself observed that complete divestiture is particularly appropriate where assets or stock acquisitions violate the antitrust laws, and that such relief is simple and relatively easy to administer. Behavioral decrees, in contrast, are inherently difficult to get right, and they rely on ongoing government oversight of what should preferably be a free market. A recent example of that is the Disney-Fox merger, where the division required the divestiture of 22 regional sports networks as a condition of the merger. This remedy resolved the division's concerns over harm to cable sports programming without needing to impose complicated behavioral conditions on how sports programming should be licensed to competitors. A third development that addresses concentration concerns is the division's work on reducing regulatory barriers. As Assistant Attorney General Delrahim recently discussed, the division's has concerns over barriers to entry. He says it's important to distinguish between regulatory barriers that are the unfortunate product of an incumbent's attempt to block innovative entrants and those that are justified by legitimate concerns. In some cases, competition enforcers may need to intervene to advocate for the removal of regulatory barriers and open up the market for new entrants. So as part of that effort, we have implemented an initiative to terminate legacy antitrust judgments, of which there are many, and this has also been discussed previously. But among those that we're reviewing, we're currently looking at a set of decrees that apply to only certain movie studios. Those are commonly referred to as the Paramount decrees. Those decrees have no termination date, and they've regulated the motion picture industry for over 70 years. By banning certain film licensing practices and even requiring certain movie studios to obtain court approval before acquiring a single movie theater, the decrees impose a distribution model on the industry. And given the vast changes in the motion picture industry since the 1940s, that may be outdated. Our review is ongoing and hasn't reached any conclusions yet, but we are analyzing whether the decrees stifle new and innovative distribution and licensing arrangements that would be efficient and beneficial to the industry and to moviegoers. Fourth, almost last, the division is on the watch for anti-competitive conduct in concentrated markets. Hardcore price fixing, bid rigging, and market allocation remain, of course, a key aspect of the division's enforcement mission. But the division is also looking at other forms of coordination and collusion that can harm competition. One example is our focus on information sharing between competitors, and that's a type of conduct that can be more effective in concentrated markets. Last month, the division filed a complaint against 6 broadcast television companies, alleging they'd engaged in unlawful agreements to share non-public, competitively sensitive information with their competitors. While the parties were not engaging in direct price fixing, they were exchanging a type of information called pacing information that could enable them to better anticipate whether their competitors were likely to raise, maintain, or lower local spot advertising prices, which in turn could help inform the station's own pricing strategies and their negotiations with advertisers. Finally, the division is looking at common ownership and interlocking directorate issues more closely. These issues become especially important in concentrated markets where coordination may be easier. Section 8 of the Clayton Act prohibits a person from simultaneously serving as a director or officer in competing corporations. And the concern behind Section 8 is that a director or officer could coordinate the business decisions and exchange competitively information between competitors. Violations of Section 8 are commonly described as per se offenses, and the lack of competitive injury from the interlock doesn't exempt the parties from liability unless perhaps one of the statutory exemptions, the statutory de minimis exemptions, applies. As today's tech platforms start competing against traditional industries and each other in new ways, this can create Section 8 or common ownership issues. Changes in technology and business strategy can cause two companies to become competitors in markets where they previously didn't compete. Recognizing this dynamic, the statute does provide officers and directors with a one-year grace period to resign. Board members should therefore pay attention to the changing competitive dynamics and be prepared to step down if necessary to comply with the statute. And recently we've seen resignations on boards of various media and tech firms as competition has evolved. There are also interesting questions about whether Section 8 applies to corporate entities created after the statute was passed in 1914, such as LLCs or limited liability companies. That's another issue that we're currently looking at closely. In addition to Section 8, Section 1 of the Sherman Act can apply where common ownership results in firms, either directly or indirectly, agreeing to share competitively sensitive information, to allocate customers, or otherwise pull their competitive punches. Lots of people are discussing whether or not the mere fact of common ownership in and of itself is an antitrust problem because of the incentives it creates. But regardless of how one feels on that issue, real problems certainly can arise when a significant shareholder actively encourages competing firms in which it has investments to coordinate their conduct rather than compete against each other as they otherwise would in the ordinary course of business. So, in conclusion, I'd like to ask each of you to reflect on where we were 15 or 20 years ago. I know on a day like today, I might send a few emails from my BlackBerry, look at catalogs from retail stores for holiday shopping, log on to AOL to browse the internet, or rent a DVD from Blockbuster. Magazines and newspapers were running articles with titles such as How Yahoo Won the Search Wars and Will MySpace Ever Lose Its Monopoly? Today, the world looks quite different, with a whole different set of firms leading the pack. And who knows what technology consumers will be using 10 or 20 years from now. But what we do know is that antitrust authorities must remain vigilant in their role as law enforcers and promote the competitive process while at the same time preserving the incentives to innovate that drive the forces of dynamic competition that have delivered these changes to our doorstep. Thank you very much. Okay. So much. Sure. Do you have any questions out there?
So you mentioned, I'm curious if you think that the Microsoft case was a good case to bring, and if you agree with this sentiment that, you know, when the Microsoft case, when it was ongoing, was one of the reasons why Google and Facebook and you know, emerging technologies company were able to succeed because there was this threat of enforcement. And then also, sounds like you don't like, or you're sort of skeptical of breakups, but did you think breaking up AT&T and, you know, prior breakups historically were good ideas, or has that changed?
So the answer to your first question, your second question are both yes. I do think that the Microsoft was a good case to bring, and I think that the remedy that was achieved there and the enforcement efforts did open up competition in ways that we're all benefiting from. With regard to breaking up AT&T, it's part of the speech that was on the cutting room floor had to do with, you know, monopolies that engage in anti-competitive conduct. And being big isn't bad, behaving badly is bad, and I think what the remedy in that AT&T case was about big behaving badly. Other questions?
You were talking about, you know, the difference. It seemed like most of the speech was about how it's okay sometimes to have concentrated markets, and sometimes those things are pro-competitive. And you mentioned things that happened 15 years ago. I was a little surprised. I attended the oral argument in the appeal of the Time Warner AT&T matter, and I was a little surprised by one of the arguments the division was making, which was basically that, you know, as long as we have a theory of harm, that we don't really need the model that proves out that harm. And the citation that was given multiple times, I know you attended the hearing too, was the brown shoe case. And it just feels like if that is the model that we're going to go towards in antitrust enforcement, where as long as there's a theory without, we have a lot more economics now than we had in the 60s and when the brown shoe decision was made. So I'm just curious what your thoughts are on whether that would be good for public policy and whether that's a good model for antitrust enforcement to basically just have, a theory of the case without necessarily proving it out with a model.
So a couple of thoughts. One of them is I shouldn't comment on pending cases and ongoing enforcement efforts. But as an abstract matter, I'll say that I think what you were thinking about in the oral argument there was really should be viewed in the context of the burden shifting conversation that was occurring, and what does it take? What did the government need to show in order to shift the burden to AT&T and Time Warner? And I think viewed in that lens, it's not quite as black and white as I think maybe you were or understood it to be. I mean, obviously there was modeling that was done, but there were also things like the model, the theory, the endorsement. And this is in the appeal briefs, the endorsement by the merging parties of that exact theory and proceedings before the FCC, where they said that this kind of conduct, this kind of vertical merger in this industry is a threat. Sure.
So you mentioned that the problem isn't about bigness, but it's about big firms behaving badly. Mm-hmm. And I'm just curious if you think that the tech giants have been behaving badly or not, because what I've been writing about are a lot of examples that seem a lot like US v. Microsoft, right? Like the Google Android case that Europe brought seems very similar to US v. Microsoft. News just came out last week that Facebook was actually allowing its API to be used by all kinds of apps, but not ones that identified as competitors, so foreclosing competitors' access to the Friends API. Amazon, we know, has been kicking off competitors off its platform and becoming the only seller of certain products. So do those constitute behaving badly in your view, or when will we get to the level of believing that they're behaving badly that we should have some enforcement?
Right. No, I'm glad you asked that question, because I'm not going to comment on any of those specific examples of conduct. But the discourse is too often, in the context of the public discourse about antitrust enforcement, is they're big, things are concentrated, there's a problem in enforcement, something needs to be done. But you've put your finger on the right question, which is conduct. It's not just size in and of itself, but it's the conduct that's occurring. So without commenting on any of those particular cases or the conduct that you identified, even if you go back to Microsoft, I mean, it's conduct. It's exactly the kind of thing you need in order to find a problem. Those are the types of things that may count as behaving badly.
Thank you very much for your time.
Thank you very much. Thank you.